Hi, welcome, or hopefully welcome back to lawcaseuk.com. I believe that I've already suggested elsewhere on this website that the most famous case to arise in this jurisdiction is that of Donoghue and Stevenson. So I'd better say that today's case is the second most famous case, although some would argue it at least the other way round. Today's case is the 1892 Court of Appeal decision in Carlill and the Carbolic Smoke Ball Company. It's a contractual case, and it is often the first, or at least one of the first cases that new law students have to grapple with. It's a case that includes many of the fundamentals that one would expect to see in a valid contract. It looks at offer, acceptance, consideration, and this thing called an intention to create legal relations. Now, before we look at the case itself, it's probably important in terms of contextual background to know that in the years preceding the events that unfold in the case, London has been the subject of an influenza epidemic, and this is an illness which is not well understood at the time. And the defendant company in the case, the Carbolic Smoke Ball Company, are the manufacturers of this device, the smoke ball, which claims to prevent colds, influenza and other diseases being contracted. Now, the defendant company not only sells the product, but it advertises the product in newspapers in this way. It suggested that a £100 reward would be paid to anyone who caught a cold or other disease after using the smoke ball in accordance with the instructions. Now guess what? Mrs. Carlill buys a smoke ball, uses it and catches influenza, or so she claims. Now here's something I'd like to highlight because I don't believe it's apparent from the judgment in the case, and that is Mrs. Carlill doesn't buy the smoke ball directly from the manufacturing company. She buys it from a high street chemist. There's no doubt that there's a contractual relationship between her and the chemist, but it's not the chemist that makes this grand claim and offers the reward. And therefore the question for the Court of Appeal is not whether there's a contract between the chemist and Mrs. Carlill, but whether there's a contractual relationship between her and the manufacturing company who make this offer of a reward. And that's really important in terms of understanding what's going on in the case, whether there's a contract in those circumstances. Now, ordinarily, advertisements are not offers. There's what termed as invitations to treat. They are inviting others to make offers. And if you need an authority for that, you can look at the 1968 case of Partridge and Crittenden. Now, in this case, the Court of Appeal decided that the advertisement was different from that ordinary rule. It was different because it offered a reward, and that, they decided, meant that in a legal contractual sense it was in some way worth a departure from the usual rule. Now, Lord Justice Lindley gives the first judgment in the case, and he examines whether this advertisement constitutes some sort of promise or whether it's merely what he describes as mere puff. If it's puff, it's nothing, it can't be legally acted upon. But if it's a promise, then that might be different. And so at this stage, the court are looking at whether there is this intention on the part of the manufacturer to create some form of legal relations by the advertisement. Now, Lindley looks at the advertisement and decides there is here an express, distinct promise, and that it was expressed in language which was perfectly unmistakable, and therefore that is capable of constituting in law an offer. And he found support, from evidential support in his conclusion there, from the statement by the company that they had deposited £1,000 in a bank to show their sincerity that this was a real potential reward on offer. So there is this promise that Lindley feels is capable of being an offer for the reasons I identified. But the defendant company then argues that it's not capable of being an offer because it's not addressed to a particular person. But Lindley gives short shrift to this particular suggestion because he says that advertisements that offer rewards are offers. They're offers to anyone that performs the conditions laid down. And when he reaches this conclusion, he relies on a string of authorities that begin with an 1833 case of Williams and Cowardine. Now, that's the offer. The next thing becomes acceptance. As for acceptance, these types of offers are accepted by anyone that performs the conditions, and this becomes what is known in law as a unilateral contract. So the court has to deal with this element of acceptance, and in particular the fact that there's no actual notification of acceptance, something we'd ordinarily expect to see in a contractual relationship. So Lindley was then of the opinion that this type of contract was very much an exception to this requirement for notification of acceptance. And in a concurring judgment, Lord Justice Bowen is with him on this point. He says that if a person makes an offer intimating that it will be sufficient to act on that particular proposal in there, without communicating acceptance of it, then performance alone will be sufficient acceptance, even if there's not notification. So Lord Justice Lindley thinks that this is an exception to the requirement for notice. But he also then goes on to say if he's wrong about this, then what we have here is a continuing offer that's being made by the company. It could be accepted at any time, and notice of the acceptance can be given at the same time as you give notice of the performance of the conditions in the offer. And therefore, when you step up to receive your reward and say, I've done what you asked me to do in the offer, that is sufficient notification, one, of compliance with the conditions, but also of acceptance of the offer at the same time. So either way round, the defendant company lost on that point. This then leaves this final issue of consideration, and here I go back to Lord Justice Bowen's judgment, and I like what he says there. He cites Salwin's definition, very old definition of consideration, as follows: any act of the plaintiff from which the defendant derives a benefit or an advantage, or any labour, detriment or inconvenience sustained by the plaintiff, provided such an act is performed or such inconvenience suffered by the plaintiff with the consent, either express or implied, of the defendant. So that is consideration. And here he decided that the use of the smoke ball was an inconvenience to Mrs. Carlill, and that inconvenience was sufficient disadvantage to create consideration on her part, and it resulted in a benefit to the defendant company, as the use of the smoke balls would help to increase their sales. So there was consideration, and therefore there was a valid offer acceptance consideration, an intention to create legal relationship, and therefore a valid contract was present. So there you have it, analysis of what for many of us will be the first legal case that we ever examine. Is there anything else I could tell you about the case? Well, maybe just this one thing, and that is Mr. Carlill, her husband, was a solicitor. If he had not been, would we have ever heard of the smoke ball and the case that resulted? Who knows?